Introduction. Basically, all contract for sale of goods are the same as any other contract. So, all the legal principles governing contract, such as offer, acceptance, consideration, intention to create legal relation, capacity and certainty are also applicable here. Sale of goods is governed by Sale of Goods Act 1957. Definition of goods. Goods mean every kind of movable property other than actionable claims and money, and includes stock and share, growing crops, grass, and things attached for or forming part of the land which are agreed to be severed before sale or under the contract of sale.
Elements of goods, which is offer, acceptance, considerations, capacity, and certainty. For contract to cease, a contract of sale is a contract whereby the seller transfer or agree to transfer the property in goods to the buyer for the price. For example, buying goods from supermarket, which is money considerations, price, goods transfer of property.
Agreement to sell. Agreement to sell is a contract under which the transfer of the property in the goods is to take place at the future time or subject to some condition thereafter to be fulfilled. An agreement to sell becomes sale when the time elapses or the conditions are fulfilled subject to which the property in the goods is to be transferred.
Existing goods. Goods already owned or possessed by the seller and may be either specified or agreed upon at the time contract of sale is made. Existing goods are goods that physically exist and belong to the seller at the time of contract of sale. Future goods. Goods to be manufactured or produced or acquired by the seller after the making of the contract of sale. Future goods are goods that are not yet in existence or that do not belong to the seller when the contract of sale is made.
Specific goods. Goods identified and agreed about at the time a contract of sale is made. Specific goods are goods specifically identified at the time a contract of sale is made. Unascertained goods. Goods identified by descriptions only. These are goods that are agreed upon at the point of making the contract of sales but are not specifically identified in the contracts.
Goods that individually recognized and accept at the time of the making of the contract of the sales are called ascertained goods. Ascertained goods are not classifiable as specific goods when the contract is made, but become identified or appropriated to the contract after the sale is made. Example, a seller agrees to sell 100 tons of the 200 tons to it at the seller's salon.
Transfer property. Transfer property have 7 sections. Section 1 is Section 18, where there is a contract for the sale of certain goods, goods defined by the description only and not identified until the contract is made. No property in them is transferred to the buyer unless and until the goods are ascertained. Next is Section 19, where there is a contract for sale of specific or ascertained goods. The property in them is transferred to the buyer at such time as the parties to the contract intend it to be transferred. S20, sale of specific goods in a deliverable state. The property in the good pass to the buyer when the contract is made. Furthermore, Section 21, where there is a contract for the sale of specific goods and the seller is bound to do something to the goods for the purpose of putting them into deliverable state, the property does not pass until such thing is done and the buyer has notice of it. Section 22, where there is a contract for the sale of specific goods in a deliverable state, but the seller is bound to measure, weight, test, or to do something other act or thing with reference to the goods for the purpose of ascertain the price, the property pass after such thing or act is done and buyer has notice thereof. For Section 23, where there is a contract for the sale by uncertain or further goods by description, and the goods of that description and a deliverable state are unconditional, appropriate to the contract, the property and the goods pass to the buyer. And Section 24, when the goods are delivered to the buyer on approval or on sale or return, the property and the goods pass to the buyer. Next is transfer risk. Transfer risk has two sections. First, Section 26. The good remain at the seller's risk until the property therein is transferred to the buyer. But when the property therein is transferred to the buyer, the goods are at the buyer risk whether delivered has been or not. Second, Section 27. NEMO that rule definition. Definition for Section 27 is no one can transfer a better title than what he has. It means that only the owner or his authorized agent can transfer the title to the goods to another person.
Exceptional rule.
Number 1. Sale under estoppel Section 27. Someone with no authority sells the owner's good in his knowledge without his objection. The owner is stopped from denying the authority of the agent to sell by holding out representing that person as his agent. Number 2. Sale by mercantile agent Section 27, who usually acts as an agent in the course of business. His authority is either to sell goods, consign goods for the purpose of sale, or to buy goods or to raise money on the security of the goods. Number 3. Sale by one joint owners Section 27 and Section 28. One of the several owners has sole possession of the goods. The possession must be by permission of the other co-owners. Number 4. Sale under voidable contract Section 29. A contract is voidable if caused by coercion, under influence, fraud, and misappropriation. Number 5. Sale by seller in possession of the sale. Section 13. A seller who has part with the tied to the goods but remain in possession of the goods can pass the good title to a BPF. The originally buyer will have to pursue his remain again to the seller and not to claim the goods. Number 6. Sale by buyer is in possession Section 13. A buyer having bought the goods, obtained possession of the good or document of title with the consent of the owner can pass a good under a sale though he has not obtained the title yet.
That's all from us. Thank you for watching.